yang sudah gabung.
Sudah.
Selamat.
Selamat pagi di sini.
Selamat
sore.
Selamat pagi.
Selamat pagi, Prof. Adrian.
Selamat pagi, Prof.
Selamat pagi.
Selamat pagi, Prof. Adrian.
Selamat pagi. Asik. Apa kabar?
Baik-baik, alhamdulillah.
Bagus.
Sehat walafiat.
Dari Ricardo berperan master kuliah.
Fakultasi kuliah master. Saya pengelola. Pak Kotibul Imam juga pengelola.
Bagus.
Lagi musim apa, Prof. Adrian di Belanda sana?
Musim gugur. Musim gugur. Meskipun semakin panas di sini, jadi sekarang kira-kira 12 derajat Celcius di luar.
Oh, iya.
Jadi sudah harus memanaskan rumah. Saya dengan pullover tebal.
Kapan ke Indonesia, Prof. Adrian?
Ya, semoga cepat, tapi ya, dalam keadaan ini mudah-mudahan saya kira barangkali tahun 2022 lagi.
Oh, jaket ya, di sini musim hujan.
Ya.
Oh, jas hujan, bawa payung.
Ya, pakai payung boleh.
Mas Pak Puput. Ini Jakartanya.
Ya itu memang sudah ada banjir di Jakarta lagi.
Ya, teman sudah selesai, sudah surut. Saya suruh pulang air.
Oke.
Pak Ricardo, gimana kabarnya, Pak?
Baik, sehat.
Masih ingat saya, Pak?
Ya,
Masih ingat saya?
nah saya ini uban saya bertambah, Pak. Jadi kemampuan mengingat tambah berkurang, ya.
Saya itu mahasiswanya Bapak, kampus MIH Jakarta. Paru-paru.
Maaf, Pak Umar. Mas Kotip, kita menunggu siapa?
Menunggu dimulai, Pak.
Menunggu dimulai, Mbak Nia.
MC-nya kan?
MC Mbak Nia.
Silakan, Mbak Nia.
We will have the discussion in English, okay?
Ya.
Okay. Good evening, ladies and gentlemen. Good morning, Prof. Adrian. Thank you so much for attending our guest lecture. I am Nia, and it is a great opportunity to open this event. As we know, this agenda is part of the collaboration between Master in Law Study Program, Master in Law Jakarta Campus, and Master in Health Law. In today's discussion, we will be discussing about the methodology of legal research and legal writing with Professor Adrian Bettner from University of Leiden, with the 10 contemporary approaches in legal research. Without waiting for the ado, I will invite Dr. Ricardo Simarmata as our today's moderator to lead the discussion. Dr. Ricardo, time is yours.
Thank you, Mbak Nia. Selamat sore, good afternoon, all participants, students. Welcome to this afternoon guest lecture, and this is the guest lecture given by Professor Adrian Bettner. Last year we had him also at the same event, and I remember the title is Legal Reasoning, Adrian, and I was also as a moderator at the time. So I'm happy to be a moderator for you, Adrian. So we are here to join or to attend a guest lecture like but Nia already said that the title is Contemporary Approach of Legal Research, of course, particularly in Indonesia. And let me introduce myself first. I'm Ricardo Sumarmata. I'm a lecturer of this faculty and also as a coordinator of the program of Master in Legal Science, Jakarta office. And for today, we already invited Professor Adrian Bedner to give his lecture on contemporary approaches of legal research. And before I ask Adrian to make his presentation, allow me to tell him about his biodata. Professor Adrian Bedner is a professor of Law Society Indonesia, and now he served as the head of department of the Van Vollenhoven Institute for Law Governance Society at University of Leiden. And Adrian's research has focused on access to justice, legal reasoning, family law, and land law. And from that focus, Professor Adrian has been involved in many research and legal education projects, and of course, particularly in Indonesia, and of course, already published numerous publication, article, book chapters, and others. So I think Professor Adrian is a right person that we invite this afternoon to say something about contemporary approaches of legal research. But before I give floor to screen to Professor Adrian, allow me to read some sentences or paragraphs that we wrote for the terms of reference of this afternoon event. In Indonesia, there has been challenges to promote multidisciplinary study of law. One prominent cause is the long domination of dogmatic study, which are in favor of monodisciplinary approach. However, this approach, this ability to explain and to solve the emergence of complex cases, has recently encouraged people to find a suitable approach as a solution. Due to the complexity of the cases, multidisciplinary approach is seen as a suitable one. In addition, this approach would be helpful for the discussion of legal reform. Non-doctrinal approaches will provide empirical data that could be helpful to formulate what law reforms should make to the existing legal rules and legal institutions. The most recent challenge to the legal studies and legal research nowadays is the digital disruption. Digital technology, where internet provides abundant information and more people favor to do social interaction in virtual world, has stimulated thought about fact and truth. It possibly rests on the examination of several foundational issues about law, such as the definition of law, the form of normative order, or even the legal values. So now we have a very important question. What would be the contemporary legal study or legal research in cope with that issues brought by changing situation? So I think we believe that let us give answer for that question to Professor Adrian Bedner through his presentation. Adrian, script is yours.
Terima kasih, Bang Ricardo. Saya diminta bicara dalam bahasa Inggris yang lebih gampang buat saya. Saya akan coba untuk bicara tidak terlalu cepat supaya jelas. Lebih gampang buat saya daripada presentasi dalam bahasa Indonesia. I'll try to speak slowly, and if you can't follow me, then please let me know. I'll start sharing my screen now.
Okay,
Yes, there we go. Okay, so I'll be speaking about contemporary legal research methods, and in the end I will say something about digitalization. Last year I spoke about legal reasoning, about doctrinal legal research. I already mentioned there that you can never do doctrinal research without taking into account insights from the social sciences, or at least insights about what the world around us looks like, and how, because law always speaks about facts. And for instance, the law of procedure is fully aimed at discovering legal facts, at actually assessing what the facts in a particular case are. So even within doctrinal research, you can never get completely out of the need to engage with reality. So that's the start.
Bahkan di dalam riset doktrinal tidak bisa benar-benar memisahkan kebutuhan untuk memiliki keterhubungan dengan realitas atau kenyataan.
Something I did last year, but I will really be talking about how actually you can indeed, and how what is happening worldwide, to what extent there is a tendency towards more interdisciplinarity in legal studies. And this is not my, next slide, sorry. Yeah. This is not my own idea or something. This is just something I'm seeing around me in the faculty when I talk with legal scholars from other countries as well. And also when I look at the rise of social legal studies, in particular in law schools in the Netherlands and in other countries in Europe, as well as in the United States. But also other places, I think, are following suit already. Now, so my slides are in Indonesian, as you can see. But the first thing I wanted to emphasize is that it's important to distinguish between the internal perspective and the external perspective. So the internal perspective, this is what we generally call doctrinal research. So what you try to do then is to find a legal solution for a particular problem, or to find a solution for a problem of systematization of the rules in a particular legal field, to make sure that the law is certain, that it is fair, and that it is useful. So what you're doing there is you're mainly focusing on legal sources, and you're interpreting them on, with the legal methods that are allowed in legal research. That's the internal perspective, and that's the core thing. That's the legal reasoning which we find to be the core business in law schools. Now, as some of you who know me and know my research, I've often argued that one of the problems in Indonesia is that there is a tendency to limit legal sources to statutory law only, so to peraturan perundangan, and not to look at jurisprudency, not to look at doctrine, not to look at practice, kebiasaan atau hukum adat, only to the hukum adat in the books instead of the hukum adat as it has developed in practice. So I think that even within the internal legal perspective, a lot of progress can be made in Indonesia. And fortunately, is currently being made by many researchers. The criticism, the critique of the way in which in Indonesia approach can be seen in the book you see below, Kritik terhadap Paradigma Positivisme Hukum, Widodo Diputro, which I think is an excellent example and very clearly shows the problems we find in Indonesian legal reasoning today. And I think it's not the only thing I disagree with Widodo is that I think the problem is not the positivisme hukum, But I think the problem is the way in which positivism is interpreted in Indonesia, which is something we could call legisme, or formalism in English. So that's about the internal perspective. Then when we look at the external perspective, that means that you look at what law is doing, or how, whether the law is fair, whether its outcomes are fair, whether the rules make sense. And there you can look at law from within social legal studies. That is the most important one, I would say. And the other is a legal philosophy. And I'll speak briefly about them in a minute. So there's many forms of social legal studies. I want to emphasize that the term is not, sometimes it's used for a specific form of research. I think that it is better to use it as an umbrella term for many ways of studying the law in with the use of psychology or sociology or anthropology, or just by using particular methods from the social sciences, for instance, going down to a court and interviewing judges instead of only looking at the judgments that they produce. Now, what then is interdisciplinarity in legal research? So I said it is to use the research results of each perspective in the research that has a different perspective. So you use insights from doctrinal law, from the studies conducted with an internal perspective, to inform the research you do in your external perspective. So for instance, for me, when I did my research on the administrative courts in Indonesia, I went through all these judgments in a legal doctrinal way and tried to understand how the judges conceived their judgments, so what their legal reasoning was. And I found some particular things in this legal reasoning which I could not explain from a doctrinal perspective only. Some irregularities and other things and particular ideas which had political reasons and which had sometimes also had to do with corruption. So there I combined the internal perspective and the external perspective. The other way around, you can also use the findings of social legal research. For instance, are community courts effective? Then you need to look at whether the people who use these courts are actually helped by them, whether it's useful for them. And that means that you have to interview those people, and then you can inform judges and the lawmaker about the results, and then the law may be changed, or the judgments. Judges may pass other judgments based on the knowledge they now have. So there is always, I would say, a clear link between the internal perspective and the external perspective. I think it's hard to do to have a fully internal perspective or a fully external perspective. But in any case, this interdisciplinarity is becoming increasingly important. And I'll say a bit more about that next. Now, I'll give a number of examples. First, let me start with the observation that in the Netherlands, as I said, but I think globally, legal research tends to become more interdisciplinary. And this is something we see not only in law, but we see it in many other sciences as well, because the problems we are dealing with are so complex that they can't be resolved unless you combine different approaches to these problems. It doesn't mean that you need to do away with disciplines. It doesn't mean that you should forget about doctrinal legal research. You absolutely should not. So the difficult task we have ahead of us is to be both legal experts, doctrinal legal experts, and that we need also to have sufficient knowledge of other research, other social scientific research or philosophy or other fields to be able to inform our doctrinal research more, or combine them in other ways. Same when you're mostly as a social sciences researcher, that you know enough about the law to be able to inform your research well. And the best scholars, I think, actually are experts both in the doctrinal side and in the social legal side, or in the social scientific side of looking at these problems. And one example I can give is the research that VVI is doing about crimmigration. Now, crimmigration is the tendency to criminalize immigration, to actually make immigrants subject to criminal laws, which is something we also see happening all over the world. And this has a definite legal side, because it is a very complex combination of administrative law and of criminal law. But it has also this very practical side. So what happens in practice with what are the effects of this criminalization, and do the effects of this criminalization not undermine the ultimate goals of the legal system as such as legal certainty, such as also human rights, for instance, but also the justice more generally. And even when we look at their effectiveness, the manfaat, we see that the effects are often completely the opposite of what is aimed for. Same with terrorism. You invent all kinds of legal ways to deal with terrorism, but in the end, sometimes you worsen the problem rather than to improve it. Now, these are the kinds of studies that are well known and have become important in social legal in interdisciplinary research. Social legal research in itself is mostly interdisciplinary, as I said. Okay, now then we have, of course, also traditionally there is an important place for legal philosophy in the curriculum in law schools, and I think for good reasons. So what is it that philosophy does? It looks at the ethics, it looks at justice, morality, and it looks at legal principles. So, of course, legal philosophy should also be based on an assessment of reality. So, some philosophers just sit behind their desk and think of all kinds of brilliant ideas, but it's always based on a particular conception or a perception of the world around them. And this is something we need to understand. And it's also something which you can sometimes criticize philosophers for, because their understanding of the world is not based on a proper assessment, on the proper facts as we can see them in reality. Now, a very good example of the importance of legal philosophy in the implementation of law and in doctrinal legal reasoning is an example which I called in Indonesian, trying to translate as the peristiwa tunjangan. In the Netherlands, it's called as the now I need to say it in English. In Dutch it's called the toeslagenaffaire. So it's a scandal basically which involves people who applied for children's support. So when you bring in the Netherlands, when you work and you bring your children to a kindergarten or to some other form of where they are while you are working, you can get a subsidy from the government. Now the problem was that these subsidies were the basis of these subsidies was a law in which was made at a time when there was a big concern about fraud, about people who were applying for subsidies whereas they were not entitled to them. So the law was formulated in an extremely strict manner, meaning that if you got the subsidy already, but if in the end you could not show all the bills, or you couldn't show that you couldn't actually account for all the money that you had received, then you had to pay back everything. So say that you had received 50,000 euros, because it's really about a lot of money in a number of cases. you had received 50,000 money and you could account for 49,900 euros. So only 100 euros you couldn't account for. And often this was the problem with the institutions taking care of the children. It was not the parents themselves which had made these mistakes. But even in that case, only with a difference of 100 euros, you had to pay back everything. So this actually afflicted thousands of people who had to pay back money which they had really used for this for their the daycare for their children, and these people went bankrupt. Some even got into such difficulties that their children were taken away from them and put in other families. So an incredible amount of human misery. Now, then your question, of course, okay, the law was wrong, but why didn't the judge do anything? Weren't there any cases brought to court? Well, the point is that there were cases brought to court. People did take their case to court, but the court, and this is the typical de PTON Blanda, is extremely strict in many ways. I think it's a bad judge in many cases, and they were extremely strict, and they had this positivistic, this formalist approach, saying no, the law says it's like this, and it's very strict. There's no proportionality, so it meant that all these people got into these problems, and that they had nothing to expect from the PTON. So what went wrong here? Well, here I think philosophy of law does offer relief, and is something that the judges should have taken on board in a very simple way, because the principle of proportionality is a fundamental principle of the rule of law, which you should always apply in any case, even if the law says that you should not apply it. You cannot. It's just like you're saying you're not allowed to be just. You're not allowed. Mencari keadilan tidak boleh. It's like you're saying that to the court. And so I think that in this particular case, the judges went completely astray, took the wrong path in deciding these cases, and actually they have admitted so much. Now, the problem was, of course, also that legal scholars didn't pay enough attention to the cases that were appearing, and didn't alert the court, and didn't criticize the court in time for them to change their. Now the government is seeking to repay these people the subsidies, which is kind of an administrative nightmare. Anyway. The reason I'm telling this story is because I think that legal philosophy and its ideas about morality and principles are important to inform a legal judgment, and that I think is this case is a good example. The next case I want to talk about is how social legal studies can be important for legal research, for doctrinal legal research, and I just tried to think myself of several ways in which this can be. So what I'm presenting now is not an exhaustive list, but there are a number of examples in which insights from the social sciences are important to doctrinal legal research. Now, the first thing we're talking about is about legal concepts. So if you have a concept like, in the past you used to have a concept like the good house father, now we have a concept like kepentingan anak, the interest of the child. And how do we define what the interest of a child is? Now, if you look in the law, you can't find it. You can find some information on it, perhaps in the parliamentary records, or you can find some information in case law, but it always goes back to insights of the social sciences about what the interest of the child is. What is in the interest of the child? So we need to look at insights from psychology. We need to look at insights from social legal studies about the effects of the legal system on children. And that needs to feed back into the practices of judges and of lawmakers. So this is a typical example. Also, when a judge, when you are confronted with a term like kepentingan anak, you need to know enough. You need to get information somehow from an expert or by studying yourself some literature or a combination of the two to be able to interpret that term in a proper manner. So even there, you need to go outside of the of doctrinal law in a limited understanding. The next one is that you can also you should also have your legal research informed about the effects that law has in practice. Now, I already told you about the toeslag, so the subsidy affair in the Netherlands, but I can give you another example. Recently in Indonesia, the minimum age of marriage was raised. Now and this, I think, was not a very well-informed decision by the lawmaker, because what we knew already was that the number of marriages of minors in Indonesia, so girls under 16 and boys under 19, was already it's getting lower all the time. So there was already a tendency that the problem was solving itself. But because international law demands that the age of a minor is 18, and because of certain ideas about the importance to raise that age, were successful in the debate, the age was then raised to 19, not even to 18, but to 19, to equalize it with the age of boys. Now, as you could have predicted, if you knew anything about the practices, what happens now is that there are millions of cases of girls of 16, 17 who get married and who don't register their marriage, or who have to apply for dispensation to the court, and who have to pay, it costs them a lot of money to actually get this dispensation. So you see that the effects of the law are not that there are fewer people under the age of 19 getting married. The effect is only that you create problems for them because they will marry anyway. It's not that they will follow the law in this case. This is the type of research I think is really important and also should be done, and it's of course an excellent topic for an article, which has consequences for legal practice. It should have consequences for the lawmaker. We should think of ways, and you can also do this yourself, of course, in an article, how you can deal with these cases, how to deal with dispensation, or whether the law needs to be changed. But as a judge also, if you're aware of this and if you're aware of the effects that this has in practice, of not, for instance, not being registered, what it means, for instance, for the child who will be stigmatized when he goes to school. These are all insights from studies, from social science studies, social legal studies, which are important to judges and lawmakers. So I think this is another good example of where a social science perspective may be very helpful for legal studies, doctrinal legal studies. Now, the next one is, it's also important to find what I call kebiasaan, to know about practice, what happens in practice. I couldn't find a good example in Indonesia because their adat and kebiasaan are sometimes intertwined. I know there's a very good example from the Netherlands, which is the following. What happened was that in the 1930s, farmers in the Netherlands insured their farm and then set fire to it themselves because of the financial crisis at the time. They wanted to get the money from the insurance because they couldn't. The farm was not profitable anymore. Now so then the government introduced a prohibition in the law to insure your farm for the costs that rebuilding would take. Now, after the war and after the crisis was over, so in the 1950s, this changed. I mean, the economic need for this matter was no longer there. And in practice, farmers started to insure their farms again for the rebuilding price. And what happened then, of course, then you had a bad insurer who received a claim from a farmer whose farm had been burned. And he said then, well, we're legally not allowed to pay you the full amount. So we'll only pay you half or something. Well, clearly the farmer was not happy with this and took the case to court. And in first instance, he lost the case because the judge, being a legal formalist, said, look, the law says you're not allowed to. On appeal, the same happened. But the Supreme Court said, no, practice in this case is already, and they informed themselves, they looked at studies concerning insurance practice, which showed that people massively insured their farm for the full amount. So against the law, but they did that. And then the Supreme Court said, in such cases, practice can even set aside a legal provision. Now, these cases don't happen very often, of course, but this is a clear case where indeed the judge used the insights about practice, about legal practice, to set aside the law. The same happens in business law. There are examples of business law where judges say, okay, in some cases the practices in business are overruling the norms found in the statute. So I think this is a very interesting and important one. And of course, as a judge, you must be very sure that there is this kebiasaan. If you're not sure about it, you can never apply it, because then you will be setting aside a statute without sufficient reason. And the only basis on which you set it aside is knowledge about the social reality. The third example, I forgot to count. The next example is a typical Indonesian one, although you find it in many countries where customary law is important as well. And this is the example I take is the case of Nenemina. Now, Nenemina is a really interesting case because it has many aspects. I'm quite sure you're all familiar with the case. The adat aspect in this case, which is interesting, and you can also find the case in the book by Widodo Dwi Putro. He discusses it there. The point was that Nenemina was actually sued, dituntut by the public prosecutor because she would have stolen fruits that had already fallen from a tree. So it's not that she picked the fruits from the tree, but the fruits were already lying on the ground. Now, what the judge did not take into account is that there is an adat rule saying that after a harvest has been picked, and if there's something left, that local farmers, local petani can actually take that from the, in this case, the plantation. So I'm not saying, I mean, there are many debates about whether this was the case or not, but the judge should at least have inquired into the possibility that there was such a shared adat rule. And how do you do that? Well, you need to actually do research in the area about the rules that are still in place, that are still there, concerning, indeed, for instance, picking up fruits which have fallen from the tree, or other parts of the harvest, leftovers, so to say, after the harvest has been conducted. So there are many examples, and I think this is a typical Indonesian field where judges could do much more in order to achieve fair outcomes. And but the knowledge, of course, of these adat rules is often limited, and the studies are often not accessible. So it takes time, it takes effort, but sometimes studies are available. Ricardo Simmermata himself, when he did his research in the Mahakam Delta, there were all kinds of practices which I would call adat. I mean, they were not centuries old, but there were new practices which had actually emerged concerning the registration of land, which I think judges should take into account when they deal with claims about land and about these new forms of registration, which perhaps don't have a clear basis in the Undang-Undang Pokok Agraria, but which are quite important and which can be seen as hukum adat in the case of Indonesia. So there is between kebiasaan and hukum adat. I think the two are quite close and should be close as well. Okay, then the next one, ideas about justice. As we know, legal reasoning does not only serve as to have legal certainty, and then legal certainty also is something you can debate about what exactly legal certainty is, but it's also to achieve justice and to achieve be effective. Now, in this case, there are quite a number of cases in Indonesia where the judges kept to the letter of the law and therefore actually did not pay attention to this idea of justice. Alternatively, there are some cases in which the judges find that the results of a case or the outcome when they look at the law will be unfair, and then they completely forget about the law, and then they start to just do whatever they like, which I think is a very bad idea as well. So you should try to combine the two, but you should do that in an informed way. The example I give here is the casus pencurian sandal, where, as you probably remember, a boy stole a sandal and then was put to jail. The sandal belonged to a police officer, I think. And in protest, people then sent, I mean, this is great, and this is typically Indonesian. No Dutchman could ever invent that. People send their sandals to the courts, and they were put there in the court just as a form of protest, which is, I think, is incredibly original. But it showed that the ideas about justice in society, and of course, you don't really need social scientific research to know this, perhaps, but it's important to know generally what people conceive as fair and as unfair. And these ideas are quite important, because if you stray too far away from them, people will see that the legal system is unfair and it will lose its legitimacy. So in the end, it's dangerous for the legal system if you do not take into account what local people consider as a fair solution. And in some cases, the judges simply need to find a way in between the local ideas about justice and national ideas about justice and about how these have found their form in the law. And for instance, and this may sometimes even lead to really, really interesting situations. There's currently a PhD thesis, which is now being examined by Arfian Shah, who writes about the 3 criminal law systems we find in Aceh. So we find the national criminal law system, we find the Aceh Sharia, and we find the Adat system. And all 3 are applied. And what judges do, and prosecutors and the police as well, is to use these 3 systems in very careful ways to make sure that they achieve a particular outcome, which is in line with the local idea of justice, but also which takes into account, for instance, the interest of the victim. And this they can only do if they really know what's going on at the village level and how people at the village level look at this. One example I can give, for instance, is that in the case of pedophilia, what they actually should be using is the Aceh Sharia, but they use national criminal law to make sure that the perpetrator will not return to the village quickly, because this traumatizes the victims, which is an insight gained from studies about trauma and about pedophilia from the social sciences. Okay. Then the final thing I wanted to discuss is that it's really important to have to take into account social science insights when you look at the context of a case. And this example, again, I selected from the Netherlands. So what happened was there was a case about a Dutch woman and a Turkish man who got divorced, and the woman fell into a depression and could no longer take care of the children. So her former husband took care of the children, and what he did was because he was working, he took the children to his parents in Turkey, where they stayed while he was visiting and partly in the Netherlands to work. And then after a year, the woman wanted to have the custody of the children. So she returned, she took the case to court again and demanded the custody. So what happens in these cases is that the judge will ask the government, the Children's Service, which is a governmental service, to look into the case and to make a report. And what they did was that they used the argument that the husband had taken the children to his parents. They used that as an argument to say that he did not really care about children. Now, this led to a lot of critique, because in the Turkish, in Turkey, it's quite common that grandparents take care of children, and that it's not necessary, that's not bad for the children, or that it will affect their upbringing badly. So the Dutch Children's Service did not take into account the cultural understandings about the best interest of the child in this case. So the context of the case was, the report was wrong about the context of the case, because they didn't take this into account. And I think in that sense, even if perhaps they might have been better off with their mother, I think the basis on which this decision was taken was flawed, because there was no sufficient knowledge about the cultural dimensions of this particular case. So you see, there is a whole range, a whole set of ways in which interdisciplinarity can be attained in legal research, and I think should be attained. And as I just said, we're witnessing that Dutch jurists, European jurists, are increasingly looking at social scientific work to inform their doctrinal analysis. And I think the analysis becomes richer and it makes more sense. Now, to show you a little bit about how this works out in practice, I went through the table of contents, or to the contents of the Nederlands Juristenblad, which is the Majalah Pakar Juris Blanda, which is extremely widely read. It's a weekly, it appears every week, and it's read by lawyers, it's read by legal scholars, it's read by judges. So it's really a forum for debate. Now, what can we find in this Majalah? The first article is about uang duka dalam kasus privacy. It's a real doctrinal piece. It's really about the systematics of the law, whether it's a good idea from a legal perspective to use the construct of, I don't know what it's in English. So it's money. It's immaterial damage. So to get immaterial damage on the basis of privacy law. So very doctrinal, looking at the systematics of the. The next article is an interpretation of the concept of privacy, and it looks at how this concept is used in being different laws, but it also uses insights from social legal research about what privacy actually is and how it works out in practice. So here we see a clear combination of doctrinal research informed by ideas from social legal research. The next article is about the community court. So the new tendency in the Netherlands, a new development, is that community courts are created. There are a number of pilot projects where courts are really put into a neighborhood to deal with local cases of generally youth who commit criminal crimes. And then the courts try to also involve other government instances to not only use a criminal law approach, but also to make sure that these people get housing and that they get a job, and so more a social service kind of approach. Now, this is a typically social legal research. It looks at what the court does, it looks at the judgments of the courts, and it looks at what happens in practice, whether it's effective. So, it's really interesting. I thought it was really, I didn't look specifically for an example where you could find all approaches within one issue of the journal, but it was just there. And this has really changed. As some 20 years ago, or even 10 years ago, the doctrinal articles would really outnumber the other ones, and now it's the other way around. There's another article in it about tahanan sementara, and that is doctrinal, also with social legal perspective, because it also looked at the practice. So what happens in practice? What does it mean for the prisons that this temporary imprisonment is taking place? So these are the articles. That's the article section. And then we come to an interesting one. We get to, there is always an important section of jurisprudentie baru. So the most important decisions, there will be summaries of the most important decisions by the European Court of Human Rights, by the Dutch Supreme Court, or by the Dutch Supreme Administrative Court. And that will be every week, each week. So these are considered to be so important that all jurists should know about it. So you see that there is the focus is on case law and not on new statutes. The new statutes are covered in the articles. They'll be discussing the articles. If there are really important things changing, the jurists are supposed to take knowledge of this in any case, but the case law is considered particularly important. So that has a special place. And actually, most pages in the Majala are about these cases. Then also very helpful, there are summaries of important new books, and the books are social legal, they're doctrinal studies, there are also legal philosophy. So summaries, so if you think something is interesting, then you know at least about it. It's being signaled to you that the book is out, and that what it's about and whether it makes sense for you to read it. So it's not a big review. It's not saying it's a great book or this, that. No, it's just a short summary, and then you can look for yourself what you want to do with it. There's also a summary of, and this is also an important section, where you find summaries of articles in a specialist journals. So, for instance, the journals for those specialized in civil procedure, the journal for those specialized in labor law, the most important journal for criminal law. So also that all jurists can get an idea about what is happening in all these different fields of law, and that they can use these insights also for their own field in some cases. Because we also see that there is an increasing interdisciplinarity within law, in the sense that civil law takes insights from criminal law on board and the other way around. And what I wanted to say is, I think the NJB is extremely important in the Netherlands. I do think that it looks a bit like Hukum Online, but it's more, I think the structure is somewhat better developed than Hukum Online, in the sense that it's very accessible, and it's very you immediately see where you want to be in the art. Hukum Online is really good, has excellent analysis of particular developments. I really like those, but it's not yet the it could get some ideas, I think, from the ANB to become even more effective.
What should I do?
But as I say, I don't know whether you all are reading Hukum online, but I think it's indispensable for jurists to read it and to know what's going on in Indonesian law. It's the best way to be informed about that. And it's really important that this was not present a couple of years ago. It's a new development and a really important one. Okay, another thing which is quite important in the Netherlands is what is called tekst en commentaar. And actually, this is not a Dutch idea, it's a German idea. The Dutch got this from the Germans. And then it must be a really good idea because many Dutchmen don't like to take ideas from Germany, but this one they did. And I think this is also a very good idea to have this in Indonesia. What it is there are annotated laws. There are statutes where each article has a commentary which shows the most important case law, jurisprudentie, about that article, shows important insight from doctrine. So for each article, as a judge or as a lawyer, you know what the current state of the art is. So there is a new edition of this each year. You can see for privacy gegevensbeschermingsrecht, it's the 7th edition. For civil law, it's the 13th edition. For criminal law as well. There are many more. I mean, these are just 4, but there are many more of these books. And I think this may be a source of inspiration for Indonesia as well. I think it will be a great help to lawyers to have such books. When it comes to interdisciplinarity, yes, it also takes on board insights from social legal studies through the doctrine, the doctrine that is being discussed in the context of the articles. So it's not direct, but it's certainly indirectly, it certainly is there. Now, finally, I want to say a little bit about digitalization. I'm very pleased that the book by Dori Reiling called Teknologi untuk Keadilan has been translated into Indonesian. I can very much recommend it to you. And why is that? Because I think that people sometimes put too much emphasis on digitalization as something worthwhile in itself, something valuable in itself, whereas of course, it's only valuable in as far as it contributes to more justice and to make processes more effective. Now, Dori Reiling herself is a judge, and she really knows what judges need because she knows the practice in courts, and she has looked at that in the Netherlands. But she also looked at other countries and also at countries with less entrenched rule of law and systems in the world, and how technology can improve that. So I think it's a really interesting book. When we look at digitalization in the Netherlands, we see that it is mainly used as a search engine. So what has changed incredibly is the search engine types, which are much more effective. It's much easier to find all kinds of materials. So you have specific legal search engines for Dutch law in particular. You also have the judiciary itself, which now publishes many more of its judgments than it did in the past. And the difference with, for instance, the website of the Mahkamah Agung is that it's much more organized. So if you want, for instance, if you want to know how the judges interpret what the state of the art is concerning Article 1365 in the Civil Code, then you can just type in Article 1365 Civil Code, and then all the judicial case law that is about Article 1365 will appear. And it will, in many cases, it will also have a few remarks what the judgment was about and what the importance of that judgment is. And then you can look in the judgment yourself to see what is really going on. Now, this the new development, and we as a Van Vollenhoven Institute, we're in the law faculty, we're next to the Department of E-Law, so the digital law department, so to say. So when I'm having a coffee in our common room, they tell me about the new developments, which is very helpful. What is going on is that that these search engines become increasingly avant-garde, increasingly tangi, and what we see is that they also can search texts for particular forms of legal reasoning. So if you, so for instance, we now know that the Supreme Court in the Netherlands, when they're going to say something important, they use a particular kind of phrase or a particular kind of turn in the narrative. And what you can do is you can have a search engine which looks for that particular phrase or that turn in the narrative. So it can select the really important judgments because you know from that the Supreme Court is going to say something important. So that is, I think, the state of the art in digital technology. Of course, it's also much more easy to find articles and information. I mean, we all use, or I hope you use, Google Scholar. I use it also to find really interesting Indonesian master theses and PhD theses, which are not published, but which you can find on the internet, or at least you can find an outline. And if you're really interested, you can send an email to the author to find it. I think it would be a great idea if all these theses would be made accessible online. I hope some universities already do this, but that would be great. And so the availability of material is, of course, fantastic. What is important is to make the selection also possible, because sometimes there's so much material that you can't just select from it. That is why I think something like NJB and something like Hukum Online is so important, because it serves the integration of the legal field as a whole, and it helps you to keep track of the most important developments. So I've been speaking longer than I planned, but I'm getting to my conclusion. I think my conclusion is that when we look at the development of legal reasoning, of legal scholarship, legal research worldwide, I think that doctrinal law will really remain important, and still is important, and will never go away. And we should take it very seriously, and it's important to use it. But it's important to use a rich form of legal research. So you should use not only grammatical interpretation, but several forms of interpretation, the whole repertoire. You have teleological interpretation, systematic interpretation, and you should also focus on various sources of law. So not only statutes, but also case law and doctrine, adat, kiasan, etc. The other one is that, and this is something important, systematic interpretation is incredibly important from a doctrinal point of view. And I think the emphasis for legal scholars in the Netherlands is very much on to systematize findings. How does it all fit in the legal system? To make sure that particular concepts are used in the same way in different forms of different pieces of legislation. I think this is a particularly important task traditionally of legal scholars, and I think that is for good reason. I think that this can be reinforced in Indonesia. I think that Indonesia could do much better in this respect. And then finally, the tendency is towards interdisciplinarity. So to use insights of social legal studies, social sciences, and sometimes from legal philosophy to support doctrinal law interpretations or for lawmaking. And this, of course, I haven't talked a lot about it, but I think in particular for lawmaking, social legal studies are incredibly important. So, and actually, in the Netherlands, there is a special bureau at the Ministry of Justice. The Scientific Bureau is called. And what they do is they assign to scholars the assessment of laws, how they work out in practice, what the effects are, and then on that basis, the laws can be improved when it turns out that they don't achieve the goals they're supposed to be achieving. So also from that perspective, social legal studies are indispensable, and they're considered legal research. I mean, it's not doctrinal legal research, but it's research which takes also into account the doctrinal perspective, and which is much richer and indispensable for improving the legal system as such. I think that was my final point. Yes, it was. So if there are any questions, I'll be happy to answer them. I give the floor back to Ricardo.
Thank you very much, Professor Adrian. It was a very inspiring lecture, actually. Why? Because I think from your presentation is clear when I asked at the beginning of this lecture, what would like the contemporary legal research? And from your presentation, we know that it is not internal perspective only, it is not external perspective only, but a combination between the two. Yeah, and you call it as an interdisciplinary approach. And you mentioned some examples how to properly relate between doctrinal approach and social legal approach. And I think that example is very, very helpful. And the way you explain the examples, I think it make master students it's very easy to understand. Yeah, it's very easy to understand. And your conclusion say that well, we need, in this case, you say that don't forget about the usefulness of doctrinal approach. We need it. Don't go away from that. But you need social research to support doctrinal approach. And for me, why that support is needed? Because that is the way we make the law, to bring the law to the society. So that's my highlight from your presentation. Without further ado, I don't want to take any time, so I give floors now to students, friends, Adrian. So first, I would like to invite some participant who would like to make a direct question, or you may also write your question in chat box. So raise your hand, please. Okay, Adrian, while waiting the question, this is a question you can find in the chat box. May I read it for you? Thank you very much for the lecture, Professor Adrian. I enjoy it immensely. It's really thought-provoking. I agree with him, Adrian. I entirely agree with you that the social legal approach must be raised at various levels in RE level system. But on the other hand, I'm actually at loss to understand how this social legal approach can be correctly integrated within RE normative legism system. Needless to say, however, I do believe and attach the greatest importance to integrating socio-legal approach into our research system. I very much hope that this socio-legal approach can complete our legal research approaches, and I do once again want to thank you, Adrian. Yeah, please, Adrian.
Yeah, no, that's a nice comment, and it allows me to make an important point. I think you're not. We shouldn't say that we're, and perhaps the main point I want to make is we shouldn't say that we're doing away with, we're not replacing doctrinal law with interdisciplinary law, with social legal studies. That is not the case. what we are doing is we are doing doctrinal law, but we use insights from other sciences to support our reasoning, and that's what I tried to show in the examples, how you can do that actually, and how judges do it. I mean, you can't say that the Supreme Court in the Netherlands is doing socio-legal studies when it produces judgment about farms that are being insured or in a particular way. It is law. It's really law, doctrinal law. And I know that Prof. Philippus and even Papiter will agree with me when I say that this is law. However, the point is, what I'm saying is that both in the doctrinal approach, there are more possibilities than are currently being used in Indonesia, but the fact that case law is seldom used actually undermines legal certainty and undermines the clarity of the legal system. And I'm also saying that not using insights from the social sciences or from legal philosophy will actually undermine as Ricardo already said, it will undermine the justice of the system and the legitimacy of the system. And of course, judges, I mean, when we look at the Pengadilan Agama, and we look at how judges there find their decisions, also at the level of the Supreme Court, that is so well informed, not only about traditional Islamic law, but also about practices which we find on the ground. So there we see many judges who really look at finding solutions to particular places, and they're not discarding the law, but they're using all the possibilities they have, interpretational. And when they use a concept like maslaha, they will not say like, look, it's like what was said 400 years ago. No, they'll look at what's happening now in Indonesian society and what is considered just and what is considered in the best interest of the child, etc., etc. So you can use these concepts to bring in insights from the social sciences, because we're dealing with practice. I mean, law is something about reality. So I think make sure that you do doctrinal law, but do it in the right way. Don't do it in a logistic way. And I recently wrote an article about Van Vollenhoven, where I'm arguing that Van Vollenhoven's argument about the Hukum Adat was also about that he was in favor of the flexibility of the Hukum Adat compared to the Dutch law at the time, because this was a time when in the Netherlands formalism, legisme, was very strong. So judges in the Netherlands produced really bad judgment in those days because they only looked at the law and they didn't look at practice. They didn't look much at case law, or only a very limited way. Yes, and so in a way, Van Vollenhoven was trying to prevent that from happening in the Netherlands Indies as well. And Eugen Ehrlich, who was the founder of sociology of law in Europe, was very close to the vrije rechtslehre, which was the same thing in Germany, where they were not arguing for replacing a law with social sciences. No, they were saying you need to also look at practice and about reality if you want to achieve good judgments. So it's as simple as that.
Okay, Adrian. That question was from Mas Philippus Andi. Thank you, Mas Philippus. So now it's
pleasure.
Yeah. Okay. Mas Oki has been waiting, Adrian. He's a master student. Now, please, Mas Oki, introduce yourself.
Yes. Thank you very much, Prof. Adrian Badner and Prof. Ricardo Marmata, for giving me the chance to present my questions. It is questions and also a kind of a, I don't know, declarations maybe. I'm a practicing lawyer, Prof. Badner, and it is my daily job is really relevant to your presentations, and I have too many argumentations with judges and my fellow lawyers regarding this formalistic and legistic way, and then I put it on written to the judges, and then they throw me out of the courtrooms, and then yeah, Yeah, and I really do believe that, Professor, this old legistic ways and old laws from the Dutches has been, I don't know, misleading the lawyers and the judges, and then I don't know why the judges uh, uh, keep have this really close minds about justice. They try to identify justice, that they try to, I don't know which similarities between justice and certainty of law. It's too far. You know, justice is never about articles. Justice has never about lex scripta, lex stricta, lex certa. It is about what happened with the people, and how the conscience of the judges give them, provide them with the thing that we call with justice. And as a lawyer, I I'm shamefully to admit that Indonesians lawyers and are only playing with love letters to the judges. I call it love letters because, yeah, we only like playing with argumentations from the papers, right? We play with the words. We try to spinning words, trying to break the elements of articles. This is not justice. We're just playing with those letters. And then I really hope that one day the Indonesian lawyers can stand in front of the court using this what do you call it, persona standing in judicio, and try to present justice, not only articles and articles, everything with articles. So I really thank you for your explanations, and thank you for your perspective and really good knowledge from me as a lawyer and then as a student. And I really hope that I can meet you personally, because I have so many things to.
I'd like to hear more. Just I also want to ask you a question. But first about what you're saying. I mean, of course, legal practice is practice with words. You can't escape that. I mean, the point is only where do you find those words, and are they only legal articles, or can you also refer to jurisprudency? And can you actually refer to insights from other sources than just statutes? And there, I think the problems come in. What I think is really important, this is also a reason why I think social sciences are so important. There is also a tendency, we all know that there is this article, Article 4, which says that the judge should be menggali hukum in the minds of the people. But then what the judges often do is that they just think themselves what the people they probably want, without really informing themselves about this. And I think this is also why there is actually a legal obligation for judges to engage with social legal studies, in the sense that if they want to know what Indonesians think about justice in a particular context, they need to read about it. They need to inform themselves about it. Otherwise, they can't know it. It's not just that you know it because you're in Indonesia. I mean, you're a judge. You were born and raised in Jakarta, and then you're a judge somewhere in Mataram or on Sumba, and people there have really different ideas about justice. So I really hope, we're in the same boat. We're hoping the same thing. But I just wanted to ask, why were you thrown out of the court, and what did you do?
Well, because the judges throw me out of the court because I kept telling him that you don't know what your job is.
Yeah, I can imagine.
I told him, one of the judges, that this is pengadilan. So we are trying to seek keadilan, not certainty of law. I don't care about the certainty of law. This is about keadilan, because this is a court. And Themis, the symbol of justice itself, is blindfolded. She was blindfolded, and she's not like reading textbook. And I don't.
She couldn't read.
Prof, thank you, Prof. I'm sorry.
No, the one point you're making an important point. I'm happy you're standing up for keadilan. I think that legal certainty and justice can very well go together. And I think they should go together, but you should interpret articles in the light of ideas about justice, and you should look at what you achieve with it. And this is where I think the first example I gave about the subsidy affair in the Netherlands, where the judge went wrong, because the judge only looked at the statute, and he didn't look at the very legal principles underpinning the Dutch legal system. And that's where he went wrong, because I think he actually went against the law by not heeding this principle. And I think that is very dangerous if judges don't do that, because they can just be completely subjected by the government, as is now happening in Poland and in Hungary. I mean, this happens in Europe as well. So I'm happy you're standing up for keadilan, but your argument could be stronger, because it's not only about keadilan, it's also about legal certainty, but it's about kepastian hukum yang adil. That's what we should be looking for.
Thank you, Prof. Werner.
You're most welcome.
Yeah. Again, this is not about choice, justice, or certainty, but you could also have it at the same decision. Yeah. Thank you, Mas Oki. Adrian, we have now two new questions in the box. No name. Dalam penelitian sosiolegal, apakah hasil penelitian yang diidealkan dapat muncul dari penelitian tersebut? Apakah harus menghasilkan sebuah rekonstruksi hukum yang baru, sebuah konsep baru, atau bagaimana?
Yes, well, okay, of course, to know what justice is really, really difficult. And it very much depends, it's very contextual. It depends very much on the case, I think. When we look, for instance, at, we take the case of a farmer who lives near a forest, who planted a tree himself, and then logs the tree, and is then arrested by the forest police because logging is not allowed on that land. And I suppose you're a judge, and you need to deal with that case. So you can either only look at this law and say, look, it's simply not allowed, you can't log there. But what you can also do is see, why actually is that provision there? Why is this provision in the law? What is the practice in this environment? Is it common to actually log trees you planted yourself? Is this a hukum adat? So you can raise all kinds of questions to get to an understanding whether putting this particular person in jail is just or not. It may be that this person was acting in bad faith and knew very well, planted the tree deliberately in an area where he knew that it was not allowed and where he had no right whatsoever. And then the case is different from when, for instance, the land is disputed, or, for instance, when the forestry department claims that the land is theirs, but that the local people don't agree with that. So all these issues should be taken into account. And if you want to do that well, if you want to know what kinds of issues you need to take into account, you should read studies about practices in forestry. You should read the studies by Willem van der Muur, Jantje Arizona, who all can inform you about the different questions which you need to consider in order to come to a just solution. So you can't reconstruct justice or anything in the abstract. It's always contextualized. It always depends on the case. But you need to get this information together to be able to actually decide the case in a just manner. So I hope that answers the question, but I think it's quite an important point I'm making now.
Okay, thank you, Adrian. Next comes from Reja Riansha. Good afternoon, Professor Bedner. How the socio-legal approach can be applied to legal issues based on differences of legal culture at the country level, such as the problem of foreigners violating Indonesian regulation because of ignorance or assuming that these actions are usually carried out in the country. For example, the actions of foreigners who violate health protocols in Bali will get deportation, even though the foreigners think that his actions are only to create a sensation because of failed
shoes, which is bad. I agree, and I think as a tourist even you should know this. But there are people who really in good faith and don't know that they should not be wearing shoes when going into a mosque. Well, if the person actually is then prosecuted for that and becomes before a judge, I think also the police and the prosecutor should also may take into account if it's clear that this was not meant in an offensive way. But that applies also to somebody from Flores who has never been to a mosque and then migrates to Jakarta and then does the same kind of thing wearing his sandals when going into the mosque. I mean, that's also a cultural issue. So yes, you should take those things into account, but only to a very limited extent. And you should really look at it very carefully and not dismiss it right out of hand.
Okay, we still have one question in the box, but for now, let's get an opportunity to Rahmat Saib for making that question. Please, Mas Rahmat.
Yes, thank you. I have a question in Bahasa, Prof. Thank you. Apakah sebuah penelitian itu harusnya sarannya itu kepada pemerintah saja, ataukah ada yang lain? Karena misalkan saya ambil contoh, apakah di daerah Aceh, misalkan di Aceh Singkil, tentu saja, apakah memang ada penelitian sebelumnya sehingga di situ mensyaratkan untuk pemerintah membentuk sebuah aturan yang bernama kanun? Nah, tentu saja keadilan di sini bukan hanya keadilan yang tertulis, sebagaimana pendapat Mas Oki tadi, tentu mencari keadilan yang ada di masyarakat begitu. Terima kasih, Prof.
Jadi saya kira itu memang tidak hanya pemerintah yang harus disarankan atau yang harus menerima saran. Jadi menurut saya penting sekali hasil penelitian itu ya tergantung dari penelitiannya. Jadi ada penelitian yang topiknya yang lebih cocok, yang lebih penting buat hakim misalnya. Jadi bagaimana pada dasar artikel tertentu dia bisa menggunakan interpretasi ya seperti disarankan dalam penelitiannya, karena hasilnya akan lebih sejalan dengan maksud artikel itu. Jadi itu jelas, dan itu saya kira misalnya dalam kasus Singkil itu penting juga bahwa itu memang misalnya advokat bisa menjelaskan, pengacara bisa menjelaskan kepada hakim bahwa karena ide-ide tertentu mengenai keadilan dalam hukum adat misalnya, bahwa artikel dalam Aceh Syariah harus disesuaikan dengan keadaan dalam prakteknya, dengan ide-ide mengenai keadilan yang hidup dalam masyarakat. Jadi itu memang tugas penting buat peneliti. Saya juga, ya saya kira sangat penting penelitian memang berguna juga buat pemerintah, buat legislator, buat hakim, buat lain. Jadi, tapi ya kami juga bisa melakukan penelitian yang kita tidak tahu, belum tahu apakah akan bermanfaat secara praktis. Jadi itu boleh juga, tapi memang kalau kita lihat bahwa ada masalah, ada problem, ada sengketa, saya kira kita selalu harus sadar ada kemungkinan hasil penelitian kami kita bisa dipakai oleh hakim, legislator atau pemerintah. So like something like that, I would say.
Yes, thank you, Prof.
You're welcome.
Nah, sama-sama, Mas Rahmat. The next question, Adrian, come from Rumawi. So he's wondering whether in the Netherlands there is also debate about internal and external perspective in studying law.
No, not really. Basically, all pakar hukum agree with what I've just been saying. And they all agree that it's important. What we see is that there is an increasing recognition that it's important. So even in a field like civil law, which is traditionally quite conservative, you now see that there are jurists studying civil law who call themselves civilologists. So one of the professors of civil law in Leiden, which is probably the most renowned chair in civil law in the Netherlands, calls himself a civilologist and uses insights from the social sciences and very explicitly to support his doctrinal interpretations. But all lawyers have been doing this a lot, because lawyers, of course, are legal professors, because they, of course, are also active in practice. So they know the kind of problems that emerge, and they know what kind of problems happen in business, for instance, which need solutions. So lawyers and jurists have always engaged with this legal practice, even in the early 20th century, in the late 19th century. Although they claimed that they were only looking at the law, they were always, of course, also looking at developments in practice. But it's more recognized now, and it's more, it's become more popular. It's always been accepted.
Thank you, Adrian. Any other comments or questions, direct or through chat box, please? Students? Okay, while waiting, Adrian. Oh, okay. Iano Anakoda, please.
Good afternoon, Prof. Adrian. Thank you all for your lecture. It's very important for me because I want to start study about social legal. Please, I want to ask you in Indonesia, in bahasa.
Boleh.
Oke. Saya ingin bertanya, Prof, bahwa di Indonesia dalam proses penegakan hukum terhadap beberapa pelaku tindak pidana makar anslah itu ada yang menggunakan penuntut umum public prosecution menggunakan istilah mena muria. Nah, mena muria ini adalah istilah adat dalam budaya Maluku. Nah, yang saya ingin tanyakan, Prof, apakah sosiologal ini dapat digunakan untuk kemudian meneliti tentang penggunaan istilah yang sebenarnya sebelum ada makar ini, istilah itu sudah digunakan oleh masyarakat adat Maluku, Prof. Apakah kemudian jika menggunakan penelitian sosiolegal saya dapat menemukan jawabannya, Prof?
Menarik sekali.
Masih harus telepon banyak orang kuliah itu.
Ya, saya kira kalau kita lihat penelitian soal itu, jadi kita harus mulai dengan mempelajari penggunaan istilah makar oleh hakim dalam jurisprudensinya sebelumnya, juga melihat bagaimana istilah itu dipakai dalam undang-undang, karena itu sebetulnya itu terjemahan dari istilah dalam bahasa Belanda, jadi saya sudah dapat pertanyaan mengenai itu. Saya sudah sebetulnya saya kirim amicus curiae kepada Pengadilan Indonesia mengenai istilah makar itu, bahwa menurut saya memang terjemahan itu salah. Seharusnya bukan makar, tapi seharusnya ya, saya lupa, tapi lebih seperti pemberontakan atau ya semacam itu, pengkhianat atau satu dari itu. Tapi dan kemudian bisa melihat bagaimana terminologi di Maluku yang dipakai untuk satu tindakan yang mirip atau ide yang mirip, apakah memang cocok dengan makar itu, dan apakah ada hubungan seperti apa, dan apakah terminologi yang di Maluku disebut saya lupa mutam Maria sorry apakah itu memang mirip dengan istilah makar seperti dipakai dalam konteks bahasa Indonesia. Saya kira itu barangkali itu kata bahasa Arab juga asalnya. Jadi analisis seperti itu sangat menarik dan sangat berguna, dan juga penting kita harus tahu bagaimana orang setempat menggunakan istilah itu, interpretasi seperti apa, dan apakah interpretasi itu juga bisa bermanfaat buat hakim, atau seharusnya hakim menggunakan istilah itu dalam konteks Maluku.
Baik, Prof. Terima kasih. Mungkin saya bisa menambahkan sedikit, Prof. Mohon izin moderator untuk sedikit berdiskusi dengan Prof. Hetner. Jadi, Prof, memang kita di Maluku itu kemudian hanya untuk mengucapkan kata menamurya yang artinya maju. Itu jadi menamurya ini, Prof, itu digunakan dulu zaman para orang tua kita, leluhur kita, untuk ketika ada dalam satu perang, satu pertempuran. Itu kemudian sebagai kode, Prof, sebagai satu sinyal ketika berteriak mena dan murya, berarti itu depan dan belakang sudah siap untuk perang. Gitu, Prof. Nah, istilah ini, karena ini saya pikir ini ranah akademisi, ada Prof. Adrian Bettner di sini, saya pikir menarik untuk kemudian saya tanyakan langsung kepada Prof. Nah, istilah ini kemudian, Prof, digunakan oleh Republik Maluku Selatan, nah, untuk menjadi untuk menjadi simbol mereka, semboyan mereka, satu istilah yang digunakan oleh mereka, tanpa saya mengesampingkan tanpa menyinggung pihak manapun. Saya pikir karena ini ranah akademis, maka perlu untuk kemudian dipersoalkan dan di-clearkan, Prof. Nah, akhirnya ketika itu kemudian disematkan terhadap mereka, orang-orang Maluku, anak-anak Maluku, anak-anak Maluku yang hanya sekedar mereka kemudian menjadi takut, Prof, menjadi khawatir, ingin berteriak atau ingin menuliskan apapun itu dimanapun berada, menamurya. Padahal sebenarnya itu sudah ada sebelum RMS ini hadir, Prof. Jadi saya ingin kemudian menggunakan sosial legal ini, Prof, untuk kemudian menjawab persoalan ini. Oke, kemudian saya tanyakan kepada Prof bahwa apakah bisa, dan kalaupun bisa maka semoga saya mendapatkan jawabannya, Prof, gitu dari pendapatnya Prof sendiri. Terima kasih, Prof.
Sangat menarik, tapi jadi masalahnya adalah bahwa ada istilah tertentu yang sudah dipakai, tapi kemudian dalam konteks historis mendapat makna yang berbeda, yang menjadi seperti merdeka di Indonesia. Jadi dan itu penting sekali, dan untuk melihat kalau dari perspektif hukum, dan apakah itu disamakan dengan dianggap sebagai makar untuk berteriak menamurya. Nah, itu juga tergantung dari konteksnya, tergantung dari maknanya yang sekarang. Kalau itu memang asosiasinya pada umumnya sekarang menjadi menamurya, dan itu memang intensinya intensi dari siapa yang berteriak, apakah itu memang intensinya untuk untuk minta kemerdekaan Maluku atau untuk mempromosikan RNS, ya saya bisa mengerti bahwa hakim akan menghukumnya pada dasar makar, itu logisnya. Apakah itu baik atau tidak, itu beda, itu pertanyaan mengenai the Unitarian State of Indonesia dan kebebasan berpendapat dan menyampaikan pendapat. Tapi penting untuk melihat bahwa bagaimana perkembangan istilah menamuria itu jelas, dan bisa saja bahwa itu menamuria masih, tapi apakah lebih, ya yang paling penting adalah memang konteks di dalam di mana diterapkan. Itu paling utama, meskipun barangkali dulu maknanya sangat berbeda, tapi apakah kalau orang mendengar istilah menamuria, apakah mereka asosiasinya langsung RNS atau asosiasi yang berbeda? Itu yang penting dari perspektif hukum, menurut saya. Dan menarik sekali kasusnya. Jadi saya
Dankjewel,
Prof. Teliti.
Dankjewel, Prof. Adrian.
Terima kasih, Yano.
Terima kasih, Pak.
Yeah. Next, please. I see here my old friend, Pak Laurel Haidar.
Yeah.
You want to say hello to?
I have no question. Yes, enjoying your lecture.
Nice to see you, Pak Laurel.
Ricardo, saya izin tanya bisa?
Oh ya, yeah. Please, Mas Justus.
Masih ingat Justus, Ombudsman? Halo, Prof.
Hey. Oh, yeah. I remember. Please, Mas Justus, please.
Saya cuma mau tanya aja, di Indonesia karena kita sudah punya Omnibus Law ya, Undang-Undang Cipta Kerja. Saya minta pendapat Prof. Adrian dalam konteks agraria, ini hak menguasai negara, ini hidup kembali. Domain verklaring yang dulu sudah dihapus dengan Undang-Undang Pokok Agraria, kemudian ini muncul lagi di dalam Undang-Undang Cipta Kerja. Nah, apakah dalam konteks itu lalu ada kita punya bank tanah di dalam Undang-Undang Cipta Kerja, lalu ada juga hak di atas HPL yang diberikan oleh negara, diberikan lagi hak. Dan apakah di dalam merumuskan aturan-aturan ini, para pembuat aturan itu kemudian mereka lupa melibatkan teman-teman akademisi sehingga pendekatan-pendekatan yang sifatnya sosiologis, yuridis, dan historis itu dilupakan, sehingga aturan itu kemudian terbit karena tidak melakukan pendekatan-pendekatan multidisipliner tadi. Nah, salah satu contoh dalam klaster agraria itu muncul kembali hak menguasai negara yang sesungguhnya domain verklaring di dalam sebelum UPA itu sudah dihapuskan setelah adanya Undang-Undang Pokok Agraria. Lalu yang kedua, Prof. Adrian, apakah di Indonesia ini kita masih perlu lagi untuk wacana peradilan agraria itu dihidupkan lagi, atau memang perlu dipertimbangkan sehingga konflik-konflik agraria menyangkut hubungan sosial konflik antara masyarakat dengan pemerintah itu bisa diselesaikan tidak lewat suatu jalur hukum yang diarahkan lewat perdata atau pidana, tetapi bisa diselesaikan dengan suatu peradilan khusus agraria. Tentu sudah banyak penelitian tentang itu, sehingga apakah implementasinya nanti bisa diterapkan. Terima kasih Prof. Adrian, Bang Ricardo. Saya kira saya sudah tidak diingat, ternyata masih diingat. Terima kasih.
Okay, thank you. Adrian, the first question is very interesting because you really want to know how social legal approach can be applied for legislation making process, ya, not only making core decision. Please, Adrian.
Ya, dalam bahasa Inggris atau Indonesia? Bahasa Indonesia aja ya. Ya, kalau pertama-tama saya kira domain verklaring secara resmi dihapus, tapi dalam prakteknya hak menguasai negara lebih luas daripada domain verklaring dulu sebetulnya. Jadi saya kira UPA justru meningkatkan kekuasaan negara terhadap penggunaan tanah kalau dibanding dengan sistem kolonial yang berada sebelumnya. Karena dalam sistem kolonial hak-hak adat lebih luas daripada di dalam Undang-Undang Pokok Agraria. Jadi apakah bahwa itu memang domain yang dihidupkan lagi sebetulnya tidak terlalu penting dari perspektif sejarah. Yang penting adalah apakah hak menguasai negara menjadi lebih luas lagi. Hampir tidak mungkin, tapi saya kira dengan saya belum mempelajari, harus saya akui. Tapi yang saya tahu dari Omnibus Law itu memang sangat pro kapital dan anti rakyat. Dan itu jelas harus ada penelitian sebelum undang-undang dibuat. Itu juga ya saya kira undang-undang Cipta Kerja memang kecelakaan buat Indonesia. Kalau dilihat kita nengok dari perspektif orang kecil, petani kecil, itu memang mendukung plantashe, kebunan, mendukung pembangunan seperti di zaman Orde Baru sebetulnya, itu idenya. Dan saya sangat, itu bukan cocok dengan kepribadian saya. Pada umumnya saya orang optimis dan juga melihat hal yang positif. Tapi dalam hal ini saya memang melihat bahwa oligarki dan elit di Indonesia, para elit sekarang sudah memang mengambil alih proses pembuatan undang-undang. Dan hasilnya sangat meluka rakyat Indonesia. Hanya yang bisa barangkali hanya satu outcome adalah bahwa kami memang mencari jalan untuk menggunakan hak asasi manusia untuk, dan juga barangkali juga kalau saya kira hukum adat memang dan pengakuan hukum adat itu ada jalan buntu dalam banyak kasus. Tapi dengan misalnya hak atas kehidupan yang layak dan sebagainya, barangkali itu bisa menjadi dasar untuk menghambat the full force of the Omnibus Law. Tapi pada umumnya saya sangat pesimis karena memang jelas bahwa pemerintah Indonesia ini hanya fokus kepada pembangunan ekonomi yang pada dasarnya modernis, yang sudah jelas bahwa tidak bisa dipertahankan, tidak lestari, it's not sustainable. Jadi saya juga tidak tahu bagaimana Indonesia kemudian dengan hasil Glasgow dan sebagainya akan coba untuk memperbaiki keadaannya. We can only try to resist in the small things, in the small cases. Mudah-mudahan ombudsman bisa membantu saya. Itu memang salah satu institusi yang paling efektif dari seluruh institusi Indonesia yang saya pelajari. Jadi I'm a big fan still of the ombudsman.
Okay, that's a good spot for.
Komnas HAM juga berani, saya kira, dalam keadaan ini. So that's what we need to. Dan jangan, dan harapan bahwa itu memang undang-undang dasar tidak diubah, itu juga penting. Karena itu bisa kehilangan Dan ini UGM, jadi saya tidak tahu apakah pernah dengar ucapan Profesor Sofyan Effendi mengenai undang-undang dasar. Itu bahaya sekali. Itu bahaya, memang. Oke, tapi itu saya akan bicara soal itu dalam 2 minggu di Cleveringa Lecture.
Yeah. So thank you, Adrian. So for information, Professor Adrian will give another lecture at 25 this November. And okay, the organizer has warned me about the time limit, so we apologize for those who want to ask, but we have to end this guest lecture. So we thank you very much, Professor Adrian, for your, I believe, I agree with what a participant said before, that your lecture is thought-provoking and also inspiring. And please let me say one very important thing from your lecture, that in order to make a legal system is better through doctrinal analysis or approach, we need to inform the doctrinal approach with social aspect, like the impact of the laws, regulation, society, the complexity of society, social concept, tradition, and as well as from philosophy. So that's last word from me. Again, thank you, students, friends, for investing your time to join this lecture. And thank you, Adrian. So see you next in the 25th.
Yeah. You're most welcome. And that will be a well-prepared lecture in Indonesian.
Okay.
Thank you, Prof. Adrian.
Terima kasih semua.
Sampai ketemu ya. Terima kasih ya.
Terima kasih Pak Ricardo.
Pak Laurel, Pak Liken.
Terima kasih.
Thank you, Prof.
You're welcome.
Terima kasih.
Tenang saya. Ketemu sama semua.